Hello, and thank you for taking the time to watch another Claim Your Justice Facebook Live session. The purpose of these sessions is to give you, our viewers, as much information as possible regarding a wide range of personal injury matters, personal injury topics, personal injury cases. The goal is to let you understand how to claim your justice when the unfortunate event arises that you, a loved one, or a family member is seriously injured in any type of accident. We welcome positive questions and comments. Please feel free to visit Claim Your Justice or call us at 888-88-KEITH. That's 888-885-3484. I've spent a number of sessions previously discussing the different types of personal injury cases and the different types of personal injuries, physical injuries, and psychological injuries that many people suffer. That's, of course, the start of any personal injury case. However, another very important part, if not the most important part, is how do the attorneys that Claim Your Justice get you the money for your injuries? Actually get you the money you deserve for being injured as a result of someone else's negligence. There's many ways. Today I want to talk about what happens when you have an arbitration and there's an uninsured motorist case. We call them uninsured motorist or underinsured motorist case. Commonly it's called UIM or UM. UM, of course, is uninsured motorist. UIM is underinsured motorist case. Most insurance policies will have language that if you as a driver or you as a passenger in a car are injured or struck by another car, or it could be a truck that didn't have insurance, your car is considered that car is considered uninsured, and your insurance policy under the uninsured motorist coverage triggers and kicks in. Underinsured motorist coverage is where you have a person that caused an accident. Let's say a car is driving, rear ends the car you're in, either as a driver or passenger, you're in that car, and that person has, let's say, $50,000 of liability insurance. However, your injuries are more serious than that, and let's say your injuries are worth $250,000. That car that caused the accident is considered an underinsured motorist. Therefore, you look at the underinsured motorist portion of your own insurance policy. Generally, whether it's a UM or a UIM case, the language in that uninsured or underinsured motorist coverage will require what's called arbitration. So that if the case cannot be resolved through settlement, where I demand $125,000 and the insurance company offers me only $70,000, you go through a process, what's called arbitration. The language on how the arbitration process works is contained within the policy. It's important that a person read that policy, of course, could be an attorney at our firm, that reads the policy so that we understand the exact language and what the requirements are, because although generally the language is consistent and similar, there are some variations. Some insurance company could require notice by certified mail. Some policy may not require certified mail. So it's important that those details are understood. After you read the information, it's important that we follow that language. We also have to give notice timely, so you can't wait for whenever you want. 3 years later, you're like, hey, I want to make this uninsured motorist case. If you didn't give the notice to your insurance company, 3 years is too late in Illinois. Now, when you go through arbitration, it's a pretty formal process. It's like court, but it's not through court. Generally, you pick 3 arbitrators. The injured party picks 1 arbitrator. The person that's representing the insurance company picks another arbitrator. Generally, people that you know from the community, the legal community, and those 2 arbitrators pick a 3rd arbitrator. And therefore, you need a decision of 2 of those 3 to decide the value of your case. At arbitration, it proceeds generally like you're in court. However, it's faster and it's a little less painless to get through the process. There will still be testimony. There's still introduction of medical records, medical bills, presentation of damages, and then the arbitrators will render a decision, and that decision is binding. Another way, an interesting way, is called mediation. Mediation is where the parties, being the injured party and the insurance company, choose generally a former judge as a mediator. The mediations can be binding or they could be non-binding. In a non-binding situation, the case is presented to the mediator gives a recommendation, there's negotiation back and forth. Sometimes it could take several hours. I was involved in a mediation that took several months. Depends on the value of the case and how far apart the parties are and how effective the mediator is. I had a case this morning where my demand on the insurance company on a case was $1 million because that was the extent of the policy, and I felt my client's damages were in excess value of $1 million. Unfortunately, the insurance company's offer was zero. Think about that, million, zero. So we went to mediation. We had a very successful mediation, and I recovered, I think, close to the full value of my client's case. That's called mediation. That's non-binding. We didn't have to agree, and if the mediator didn't come to a fair and equitable decision among all parties, the case would then proceed to arbitration. These are nuts and bolts. I want you to understand the process isn't just get injured, get a check. When there's an uninsured motorist case, they're generally easier to handle through the system and process to the resolution of actually getting a check. So remember, when you hire Claim Your Justice, you'll get effective representation, you'll get experienced representation, and you'll get lawyers that care about you, your family, and your case. When you have an injured in an accident, call 1-888-88-KEITH. That's 1-888-885-3484, or feel free to visit us on the web at claimyourjustice.com. Have a nice rest of your day and a successful rest of your week. Thank you for listening.